afternoon, everybody, and it's a pleasure to see you all. So I think we can slowly get started, and I see more people will start connecting as we go along. My team is telling me it's approximately 100 people on Facebook as well. So we have an audience of about 300 people for today. We had about 400 people RSVPing for the session. So once again, good afternoon, everybody, and welcome to this Creative Zone webinar. Today's topic is changes to the 2022 UAE Labour Law. As we were just saying in the introduction, there's quite a few interesting new announcements coming, and especially the fact that this came online starting the 2nd of Feb, which is yesterday. With us, we have Tapp and Michael Chattle. Tapp is the head of the Pinsent Masons Middle East employment practice. Pinsent Masons is listed as one of the top law firms around the world, and they've been in the UAE market for over 20 years. I understand that Pinsent Masons was founded back in 1769, which is quite incredible trajectory, I would say. And definitely it's a real pleasure to have you here, Luke. And Michael is also a UK qualified solicitor. He's an expert on employment law and across many jurisdictions in the UAE, Middle East, Europe, and Asia. So to our attendees, I think it's a real honor to have two very proficient and professionals on this topic of labor law. And I think this shows the interest that a lot of people in the UAE and business owners have in understanding more about today's topic. So I understand that, Luke, you guys have a nice presentation to share with us, a few slides. But before we get going with that, if you could give us a bit of an introduction, maybe first of all on who you are, Tapp and Michael Chattle, and then what are the main pillars behind the changes of this 2022 UAE Labour Law?
Yeah, thank you. Thank you very much, Lorenzo. Thank you very much for those kind words about the firm and about our practice here in the Middle East. As you say, Michael and I, we're employment law specialists. We're both based in Dubai. I've been here for 10 years. Michael's been here for a little bit less than that. But we both practice employment law in the UAE on a day-to-day basis. We're part of a bigger team. So there's additional employment lawyers that are based in our Dubai office. And in addition to that, as you say, Lorenzo, we're one of the largest firms in the world, really. Head office in London, in Dubai, as you say, been here for over 20 years. And we've got 14 partners, about 60 lawyers in our office in Dubai. I'm in the office today, specializing in all areas of law, so not just employment law. But in terms of the new labour law, which is what we're here to talk about, I mean, it's a fantastic development. I think everybody that's either an HR specialist or an employment lawyer or an in-house lawyer, managing director, was pleased that the authorities have finally published and now implemented a new labour law. What are the pillars? What are the reasons for introducing this new labour law? I think that probably the first reason, the obvious reason, is that the old law was the law number 8 of the year 1980. It was 42 years old this year, and it was designed and created for a very, very different society, different economy, different workforce to what we have in the UAE now. It was designed very much for a blue-collar workforce, and a lot of the provisions and the regulations within that labour law reflected that. You know, there was a lot of language that was relevant to blue-collar workforce. And what we've seen over the last 20 years, in particular in Dubai, is a diversification of the labour market. We have great organisations like yourselves at Creative Zones. We have professional legal sector organisations, strong financial sector. All sectors are represented now, and a real variety of professionals working in the UAE. So the labour law needed to be updated. And I think that's what drove the change. And then in terms of what are the objectives from the authorities, that's a really easy answer to that in terms of why they put what they put into the labour law. That's set out actually in Article 2 of the labour law that says, look, the objectives of this labour law that we're drafting, we're implementing yesterday, are to attract and retain world-class talent. So there's a focus there on employees. It's to create a balance as well between protecting employees, making it, you know, commercially and practically possible to do business in the UAE, so helping companies where appropriate as well, and ultimately trying to support the growth of the economy of the UAE by balancing those two disasters. And we see that, and we'll talk about some of the provisions in detail as we get into the session today, but we see it in different areas. So, for example, there's new anti-discrimination provisions that we'll talk about. You would say that protects employees, right? That will make the UAE a more attractive place to come to work. But equally, there's provisions there that give better protection to companies as well. So we'll see today in the discussion, but we think the balance is being achieved in this new law.
Excellent, excellent. Well, I will suggest to the attendees to put your questions on the Q&A section or even in the chat section. We're going to try to read them as we go along. I have a feeling that the team, Luke and Michael, are going to be dividing this into the key main pillars of the changes. I understand that there are 6 main areas that have been sort of introduced new changes to. So we're going to take it, item by item, and we're going to try to read a few questions as we go along. So to the attendees, try to put your questions there. If we find that there are some relevant things for us to bring up, we will do. We have in total about 50 minutes left for today, and we're going to do a combination of the presentation that Luke and Michael have taken, put for us today, and we're going to be reading a few questions. Maybe Michael, from your side, a bit of a snapshot look into what's going to happen today as an introduction, and then we can get going for the presentation.
Sure, yes. So thank you, Lorenzo, and hi, everyone. So yeah, as Luke mentioned, I'm also an employment solicitor here in the UAE, and working as part of Luke's team, specialising on all things employment, whatever it is, right from the start of employment and recruitment right through to termination and everything in between. So yeah, I've been in the UAE about 2 years now, working with Luke's team, and yeah, so I think this is a really exciting development in terms of an employment landscape in the UAE, and really will have a big effect in terms of how employers will interact with their employees going forward. So I think, Luke, you've got, should we start the slides?
Perfect. Yeah, so the slide should be showing now, and I think Michael said he could see the slides there. Great, so let's start and jump straight into the slideshow. As Lorenzo says, I remember we did a session, Lorenzo, during the pandemic, well, at the height of the pandemic with your clients at Creative Zone about 18 months ago now, and it was a great session, really interactive. And as Lorenzo says, do keep the questions coming in, and Lorenzo will be picking up on them as we go through the session today. So let's move on. So we mentioned Pinsent Masons, nothing to say other than these are the offices where we have a presence. I mentioned during the introduction, we're in Doha and Saudi Arabia, as well as Dubai. This is the agenda for today's session. As Lorenzo says, there are really 6 key topics for us to discuss with you today. I mean, all areas of the employment relationship have been updated by the new labour law, but what we want to achieve from today's session is to give you some really practical takeaway points to say, okay, this is what I need to think about over the next week, over the next month, as this new labour law begins to take an effect on my workforce. This is what I need to be thinking about. These are the risk areas. This is what I need to do. And that's what we want to talk to you today in relation to these 6 key areas. But we wanted to start on the new working week because, of course, this has been such a hot topic over the past month, really, month to 6 weeks, when the authorities announced that the public sector would be moving their working week from Sunday to Thursday to Monday to half a day on Friday. And I think what's really important for us to explain to everybody today is that from a private sector perspective, this is not a legal change that anybody has to implement. What happened was the government changed for the public sector. There was a change for the school week as well. What we've seen with our clients, with our community, is that a large proportion of the private sector have moved to a Monday to Friday week. But as I say, it's not legally mandated. In fact, the only thing the new labour law says about this new working week, it doesn't say anything specific about the new working week, but under the old law, under the 1980 law, Fridays were always carved out as a rest day. So Fridays were the official rest day under the 1980 law. Under the new labour law, Article 21 of the new labour law, there's a reference to a weekly rest day, but it does not say it has to be Friday. In fact, it doesn't name a day. It doesn't say it has to be Saturday or Sunday or anything. It just says companies are required to give their employees at least one rest day per week. That day should be identified in the employment contract, but it doesn't go beyond that. So like I say, we've seen the majority of the private sector move over to Monday to Friday, but there is still discretion from a legal perspective for companies to design their week with whatever works best for their organizations.
First question I can throw in there, is there still a minimum or maximum amount of hours that an employee is able or supposed to work during a week?
Yeah, I mean, a great question, Lorenzo. And actually, it's a little bit ambiguous because there's two different provisions that deal with working hours. So in one of the articles, it says 48 hours per week, which is the same as what the position was under the Labour Law. What's really interesting, though, and creating a bit of confusion for clients, we're getting a lot of instructions on this point, is what about overtime? Because there's a section in the new Labour Law that says under overtime, the maximum working hours over a 3-week period is of 144 hours. If you divide 144 by 3, it works out to 48 hours per week. But what that seems to be saying is that even including overtime, you can't do more than 144 hours over any 3-week period. Now, it's unclear whether that is deliberate or whether overtime can actually be worked additional to that. Because, for example, we talked about the blue collar workforce earlier, construction sector. You know, we know that a lot of construction companies do pay overtime. They do allow staff to work more than 48 hours a week, but it's a really important part of the remuneration from an employee's perspective, that overtime pay. I think for a lot of the clients joining the call today, just have in mind 48 hours is the maximum working week, and to the extent possible, your employment contract should reflect that.
Excellent.
So just one more slide on the working week, the considerations that our clients have when implementing a new working week. Some thoughts to take away: trial period or permanently fixed. We generally are recommending to clients where they can suggest this new working week as a trial period, see how it goes. There may be some sort of unintended consequences of the new working week that you want to iron out. Obviously, if it's a trial period, it gives you more discretion to change it around a little bit at the end of that trial period again. Consultation, or do we just make a contractual change? Clients are having a very short consultation period. You know, it's a couple of emails to all the workforce. It's maybe inviting people to raise questions, maybe a town hall conversation, nothing beyond that. And there's nothing in the law that requires anything above and beyond that short consultation. Friday prayers, what do we do about Friday prayers for Muslims who wish to observe the Friday prayers? Majority of clients are recognizing that and are saying, okay, with the new Monday to Friday, if people wish to take a prayer break, that's absolutely permitted. Some clients are saying it can be up to 2 hours. Some other clients are not putting a time limit on it and just saying, okay, just, you know, take the prayer break in accordance with the timings that you require. But the market practice, from what we're saying, is that Friday prayers are being permitted and being allowed. Discrimination's a point that's been raised by a couple of clients, and Michael's got a couple of slides on discrimination today, because there are new anti-discrimination provisions in the new Labour Law where you cannot discriminate against people on the grounds of race or religion. And obviously this is a sensitive area, working on Fridays, giving prayer breaks to Muslims and maybe not giving it to people of other religious beliefs. So it's just something for clients to be aware of with this consultation procedure and be sensitive to these types of issues that can arise. And of course, you know, Lorenzo was talking about Qatar earlier. I mentioned we have offices in Qatar and Saudi. We have clients there as well. And so from time to time, our lawyers have to work on the new weekend. They have to work on Sundays. And it's just maybe in thinking about introducing an agile working policy where people maybe work on the Sunday, take a bit of time off in the week to recognize that. Those are the sort of issues that clients are managing at the moment as they move into the new working week. And that's really all we wanted to mention in relation to the new working week. But the new Labour Law. So Federal Law Decree number 33 of 2021, I mean, Lorenzo asked a great question earlier about what are the pillars, what are the objectives in relation to the labour law. And as I say, this, what we've got on the slide here is really copied out from Article 2 of the labour law, which sets out what the objectives of the authorities and the government are in relation to the new labour law. As I say, it's really about achieving a balance, about creating an environment where world-class talent and world-class organisations are able to grow and be successful in the UAE. I think a really key point is that third bullet point there in relation to enhancing flexibility and sustainability of the labour market. And again, we've got a slide in relation to flexible working, because that's something that's been a real priority of the authorities. And throughout the talk today, and people will have come across references to executive regulations. They're referred to a lot in the labour law, executive regulations. So where they talk about particular topics, it says this topic on flexible working will be developed by executive regulations when they are published. And the authorities last month, so in January, confirmed that they had approved the first set of executive regulations to support this labour law. Now, we have not yet received a copy of them. They have not yet been published. They've been approved, they've not been published. As soon as they're published, we'll be sharing them with our clients and community. But importantly, at the time that they announced that they'd been approved, the authorities said these regulations will again focus on that flexible working arrangement and will introduce some new visas. So as I say, this whole new types of working, it's things like part-time working, it's working in different ways, perhaps working from different locations, working with different visas, is something that's a priority of the authorities. They know that's how the new generation of employees like to work, with more flexibility, and that's going to be recognised in this labour law, but also in the executive regulations.
Luke, do you feel that now, since we've seen the changes, is this new change to the labour law kind of adapting to this new reality that a lot of the companies are having to work with, which is exactly this: more flexibility on the way that we work, people working from home, people working from other parts of the world?
Yeah, thanks, Lorenzo. There's definitely a move towards that, 100%. And there's language in there that talks about that sort of flexible working arrangements. And the authorities absolutely are in touch with that. They want a really strong technology sector, for example. And as you say, Lorenzo, the people that work in those sectors want that flexibility. So there's definitely a movement towards it in the labour law itself. But in terms of practical visas, how's it going to work in practice? I think that's going to be following through in the executive regulations. But absolutely, Lorenzo, I think this really is an objective and motivation of the authorities to make it a more flexible working environment.
Excellent.
And we thought this is a really important slide to have at the beginning of today's session, because a lot of time companies will say, so what? The labour law says this, so what? What's the risk? What's the damage? Where's the exposure? And under the old labour law, the financial exposure was pretty limited, because even if you dismiss somebody unlawfully, the maximum compensation you would have to pay to that person was capped at 3 months' pay. And compensation for an employee, by the way, is still capped at 3 months' pay under the new labour law. But this, on this slide here, is entirely new. And I think it is quite a game changer from an employment law perspective, because the answer to the so what question now is these points, and particularly that third bullet point again, the 5,000 to 1 million dirham fine that we've highlighted in bold there. Because what the authorities now have the legal ability to do to organisations where there is any violation of the UAE labour law is issue a fine of anywhere between 5,000 to 1 million dirhams, about £200,000. So, and that can be potentially, that's any violation whatsoever, whether it's an act of discrimination or whether it's employing people without the correct visa, or what, it could be anything. And there's no guideline.
What would you say is the most common violation that you see in the labour law here in the UAE?
I'd say in the past, it's probably been around dismissals. and you know, the courts awarding arbitrary dismissal against unlawful dismissal against the company for failing to follow the correct procedure. That's been a pretty common violation that we've seen from the company side. And I think from the employee's side, and we'll talk about this actually in gross misconduct dismissals, something that frustrated many clients was where an employee was somehow making money for themselves without disclosing it to the company. So a little bit of corruption, perhaps, you know, gaining kickbacks from suppliers, for example. But the difficulty clients always had was Article 120 never specifically said that's a gross misconduct offence, whereas that's been added to the new labour law. So in terms of breaches from an employee side that were not picked up on before by the labour law, that was something, and that's been addressed in the new labour law.
Excellent, thank you.
So on to the next topic, and this is, we put this number one in terms of the 6 key topics to talk about today, because this is the one that clients have been in touch with us about the most, employment contracts, because companies you have to change your employment contracts. Everybody on this session today, all 300 of you have an organisation in the UAE. You have to change your employment contracts if they are currently unlimited term contracts. And I know that 90% of you private sector organisations, including Pinsent Masons, have employees that are on unlimited term employment contracts. So it's a really key difference, and it's one that's made the headlines, that under the new labour law, the only concept of an employment contract is a fixed term employment contract. That's when it's for a defined term. It could be up to 3 years. It could be a 1-year fixed term, could be 2 years, could be 3 years. So I want people to take that information on board and think about updating their employment contracts. We've obviously worked with a lot of clients over the last month to get their contracts so that they're in accordance with the new labour law and so that they're fixed term going forwards. The challenge for all of you is going to be converting your existing staff onto fixed term contracts as well. You have 1 year to do that. You can see that the final point under the subheading new law, 1 year transitional period. So you've got until the 1st of February 2023 to convert your existing staff onto a fixed term contract. But for new joiners, we're recommending that you update your local contracts so you are putting people onto fixed term contracts in accordance with the new labour law.
So the recommendation is to go out now and redo all employment contracts with all employees under this under companies, yeah?
Yeah, well, I mean, the recommendation is to definitely update your template contract. So next time you're hiring somebody anytime this year, it's a fixed term contract in accordance with the new labour law. Please do that immediately. And then in terms of existing staff, you do have 1 year to put them onto the fixed term contract. But obviously, the sooner you do that, the sooner you make sure you're complying with the new labour law. But you have to do it. You have to do it. So it's something to start thinking about now.
Great.
And
flexible working, Michael, I think, yeah.
Sorry, just on pick up a question that's been asked in the chat, just how that change in contracts affects gratuity payments. So I think the key point here is that continuity of service continues. So whether you're converting existing staff onto the new fixed term contracts, or as you go forward, you're renewing fixed term contracts, unless there's a break in service, so the employee actually leaves your employment until you pay out gratuity under the old contract, their continuity of service just continues. So when you do come to calculate gratuity, when they do eventually leave, you take into account their entire employment. So you don't, for example, pay out gratuity at the end of each fixed term contract. As soon as that renews, it just keeps going and going until they do eventually leave your employment.
Thanks, Michael.
But so yes, so then picking up on the next point around flexible working, this was an area where previously there wasn't a lot of choice or flexibility for employers or employees, not a lot of options available. The ministerial decree in 2018 did start to change this, allowing part-time visas to be issued, and then this was then built on further under the COVID regulations, which did allow some more flexibility around remote working. But what the new law has done has introduced different, an increased number of different models of employment. So We've put the key ones out on the slide in front of you there. So there's part-time, which similar to as it was before, following the ministerial resolution, is where an employee is looking to work for multiple employers, you know, on specified hours or days. Then there's temporary working, so where employees are working for a specified period of time for a particular employer. So most commonly we see this around projects, for example. You know, if you just need extra staff, extra resource to carry out their project, rather than taking on a you know, a full-time employee or a long-term employee, there's now this option around temporary employments. And then there's a new focus on flexible working as well. So work that has different, for employees work different hours, different days, you know, so no necessarily set working schedule. So really when it depends on the requirements of the job. So these new options do give a lot more choices to employers about the type of staff they hire. It gives increased choice to employees about what type of work they carry out, when they carry it out, and also around the different visas that you can get. So it increases the ease of employees getting the right the right job and right visa for their particular situation. Now, this is, as you know, Luke mentioned the executive regulations earlier. This is an area where we are. It is subject to further regulations being published around the obligations with each model of employment for the employers and employees. So this is an area that is going to be subject to quite a lot of further guidance. So if you think this is an area that you might want to be taking advantage of in the future, this is definitely something to keep an eye out for, about how this evolves in the near future when the regulations are published. So then moving on to employee benefits. So here we're talking about the minimum level of benefits that all employees are entitled to. So this is kind of the base level that all employers must comply with. Now, it's not to say that employers can't enhance this, can't offer more than these benefits, but this is kind of as I said, the baseline. Now, largely we haven't seen there's not been a dramatic change in these under the new labour law. We've set out the key ones on the slide there in front of you. So just to pick out some of the key changes: annual leave, the actual entitlement hasn't changed. So for employees from 1 year service onwards, it's 30 calendar days. But really where the biggest change is around carry forward of holidays. So where an employee hasn't used all of their holiday in one particular year, whether or not they can then take it forward into the next holiday year. Under the old labour law, employees had to either be paid out of this holiday, or they had to be allowed technically to carry it forward as much as they had left. Now, that could often lead to a rather difficult situation where employees are accruing quite a lot of annual leave, and quite difficult situations for employers to resolve. Where an employee has a particularly large entitlement. Now, under the new law, that situation has changed, and employees can only carry forward holiday where the employer agrees to it. So, really, that this is a very welcome change, I think, for employers, and it means we're aligned with most other major jurisdictions. So really, I think we'll see going forward, either employers will take a position of not allowing carry forward and operating a use it or lose it policy, or limiting the number of days carry forward. So a common policy would be to allow, for example, 5 days to carry forward, to really limit how much is carried forward. And this is where you really want to make sure your contracts are in good shape, to make sure it's very clear on that, so there's no ambiguity between employers and employees. Now, maternity leave hasn't dramatically changed, as I said, but it has been enhanced slightly. So while previously there was a right to 45 days full pay, now that 45 days full pay still exists, but there has also been an additional 15 days of half pay introduced on top of that. And then there are also some slightly more subtle changes around it. So, for example, under the new law, employees who have a miscarriage after 6 months of pregnancy are also entitled to maternity leave. And then, so paternity leave and your sickness absence, you'll see, also haven't changed. where there has been change is around this introduction of new concepts of leave. So around compassionate leave. So there's 5 or 3 days, depending on who has passed away in the employee's family, and also this idea of study leave. So 10 days paid leave for employees that have been employees for over 2 years, and also are studying for a qualification within the UAE. So for a UAE educational establishment. So I think the key takeaway on this point would be to make sure that your policies are up to date, that you'll make sure you are compliant, and that your policies make sure you are communicating what employees are entitled to properly, but also you're fully protected as an employer around this. So, for example, study leave, you will want to make sure that if an employee is entitled to it, you have got a policy saying you must must provide us with notice, you must provide us with any evidence we require, stuff like that. So although it might seem straightforward, actually there can be some nuances around it where you want to make sure your policies are up to date and compliant.
Michael, we have one question in regards to the annual leaves that are being carried forward from the previous year. The question is on the area of, in the case of a dismissal or the employee leaving the company, are those to be paid in the case of these annual days that were carried forward for the next year?
Yes. So if you have allowed an employee to carry over holiday annual leave to the next year, and they are then subsequently dismissed or leave before they've used that entitlement, then yes, it will count as their entitlement. So they will need to be paid out of, which is a factor. Sorry.
So according to the law, what's the maximum amount of days that an employee is able to carry on to the next year?
So that's subject to agreement with the employer. So there's no set cap. It's subject to whatever is agreed with the employee.
Yeah, I think that's absolutely right. So for last year, under the old Labour Law, the reference to annual leave carry forward, as Michael says, it was never capped. And what we saw with court decisions is that they would look back 2 years to see how much leave a person would have accrued over the 2 years before the end of their employment, and then the company would have to show evidence that the employee had taken that leave. And if they couldn't show the evidence that they'd taken the leave, the court would award them 2 years worth of annual leave. And we saw that in judgments. What's interesting under the new Labour Law, in that box in the top right hand corner, is that there is a reference to that being limited to a maximum of 5 days. So as Michael says, it's possible to agree that it can be more than 5 days in a policy or in the contract, but companies may also limit it to 5 days, and they've got legal support to do that under the new Labour Law as well. So I think it's an area where it may be worth clients looking at their annual leave policy, looking at their contracts, because if they do want to limit carry forward, then they now have a bit of legal support to do that. And like I say, cap it at 5 days, but it is possible to allow them to carry more than that, of course.
Excellent. Thank you.
So then, as Luke alluded to previously, there are these new also anti-discrimination and harassment laws under the new law. And previously, this was an area where the Labour Law was largely silent. There were no direct anti-discrimination or harassment provisions in the old Labour Law, with the exception of the equal pay provisions, which were brought in within the last 18 months or so. Instead, any protection around in this area was around wider anti-hate laws, but these weren't focused on employment specifically. So they did provide some element of protection, but really not that much. So what the new Labour Law has done is introduced new direct protection for employees against discrimination. So under the new law, employees can't be discriminated against on the grounds of their race, colour, gender, religion, national origin, ethnic origin, or disability. Now, these provisions are very welcome from an employee perspective, and they are an area where employers do need to make sure they are being very careful going forward, in particular because while obviously we don't know for sure yet the approach that courts will be taken, you can see that the courts, when looking at the level of fines that Luke talked to previously, so it's a range from 5,000 to 1 million, you can see how discrimination cases could potentially be on the higher end of that scale than perhaps other breaches of the labour law. So this is an area where employers have to be very careful. Now, the provisions we have so far don't have quite some of the detail that, for example, the IFC provisions around discrimination have. So we will be looking at how this area evolves. For example, is protection against discrimination, does it extend to indirect discrimination? So rather than just clear direct discrimination, but really, generally, this is a good step forward for employee rights. Now you see on there that the important carve out is that positive discrimination in favour of Emiratis is permitted, so that wouldn't be classed as discrimination under the labour law. And then also the equal pay provisions that were introduced late under the old labour law do also continue to apply under the new labour law. So employees are entitled to equal pay for equal work. Now, what exactly is classed as equal work is also something area to be developed a bit further, but that is an area where employers should check their payroll, how much they pay employees, to make sure that employees that are carrying out equal work are being paid the same. And then also
sorry to interrupt there, Michael, maybe because there's a good question on this topic. And again, what would you say are the most common mistakes that employers make on the issue of discrimination? There's a question from Louise. She's saying, as a recruiter, we're often asked to help clients diversify their teams, bring in a female worker as the team being at the moment 100% male. How can we legally request this without appearing to be discriminatory?
Yeah, and that is a very good question, and it is a tricky area because obviously there is a balance to be sought between discriminating for obviously for not so good reasons, and then discrimination for what could be seen as positive reasons, but still could technically fall foul under the law. So that is an area where we'd have to see, for example, if a certain amount of discrimination could be justified. So, for example, if you require a particular type of person for a particular role, and there is good reason for that requirement, then there is going to be potentially some flexibility in it. But I think really this is an area where I think we're going to want to see some of the executive regulations and how that builds on what's been included in the labour law to give some element of clarity to employers. Great. And then a final point there is this protection around sexual harassment in the workplace and indeed other types of harassment as well. There is also increased protection for employees about, for example, bullying in the workplace and how employees are treated. So really the action points here is similar to employee benefits, is to make sure your employers' policies are up to date and in place. So you do have an equal rights policy, for example, an anti-discriminatory policy, and also dealing with harassment, and that your employees and managers are trained on this to make sure that all employees know what's expected of them, know what the company's position is on this, and so that you do, even if then discrimination does occur, you do have then something to fall back on and say, we took all steps we could to train our employees to make sure that no discrimination took place.
Thank you, Michael. Were there any other questions on discrimination, Lorenzo, before we move on?
Look, we have dozens of questions on discrimination. It's going to be difficult to tackle them all, but and I know that we have another 10 points to go through in this presentation. I think we're going to have a tough time covering all the points in today's session. Maybe I'm going to start putting this out as well to our tech team. We have an email that is legal@creativezone.ae. Our tech team maybe can put this, and how we will be working with Pinsent Masons on this is that we're going to be forwarding a lot of these questions directly to Luke and Michael. This will be treated on a basis of consultancy for those that would like to, receive information and maybe engage with Luke and Michael on their services, we will be forwarding all these questions to them. And then you guys can take it forward in terms of the advice that you will be giving. But for anybody that has questions on this, please feel free, whatever we're able to answer ourselves internally as Creative Zone. If you're a Creative Zone client, we'll be happy to do so. And then, as I said, we'll be coordinating with Luke and Michael on forwarding those to them. The tech team will put the email now on the chat section. But yeah, let's go ahead because there's so many questions on so many topics.
Perfect. Thanks, Lorenzo. And yeah, sorry, guys, obviously we won't be able to answer all of the questions today, but as Lorenzo says, feel free to get in touch after the session. And yeah, we're more than happy to follow up with any of those questions. Okay, well, we only have, I think it is only two particular topics that we wanted to go into a bit of detail that are remaining for today. The first one is end of service gratuity. Now, we have received lots of inquiries about gratuity this week because there has been some important changes to the way in which gratuity should be calculated under the new law. And also there is a bit of confusion and ambiguity in the language that's being used. So all of you will be familiar with the concept of end of service gratuity. It's the payment on the termination of employment. This is what the calculation was under the old law, actually under the 1980 law. Now this is the position under the new law, and a couple of really important points to share with you today. First of all, there's confusion about working days or calendar days. And I saw one of the comments in the session earlier asking for an official translation of the new labour law. There isn't an official translation of the new labour law. It's an Arabic language law and it's subject to translations by legal resources. But we do have an Arabic-speaking employment lawyer in our team at Pinsent Masons who has been studying the law in detail. And the issue here, the top bullet point, is what is the value of the daily rate? Because if we go back to the calculation, it's still 21 days basic pay for each year and then 30 days basic pay for every year above 5. But whether it's working or calendar will have a big impact on the calculation, because to get to the daily rate, if it's a calendar day daily rate, you divide the monthly basic salary by 30, so it's a smaller number. If it's a working day daily rate, you divide the monthly basic salary by 22, so it's a higher number. And obviously then when you're multiplying it by years of service, it's a significantly different total number for the company. So the way it's drafted in Arabic, this piece of the law, it does not actually define whether it's working or calendar days. So that's where the ambiguity comes from. Although we know at least one translation of the law talks about working days, which would be a complete change to what it was under the old labour law. So that's a bit of confusion there for clients to be aware of. However, there's another point for clients to be aware of at this moment in time, because under Article 68(3) of the labour law, it's very clear in the new law that it says any contracts that were agreed under the 1980 law that are still applicable, are still unlimited today. In those circumstances, gratuity can be calculated under the old law. So for people, and this is the reason we're getting inquiries, because of course, clients have employees resigning all of the time, and this is going to come across your desk quite quickly, I'm sure, if somebody resigns. What formula do we use? Well, if they've resigned and they're still under the old contract, under the old law, you still could refer to the 1980 law, which keeps everything simple for now. And then we're hoping there'll be some executive regulations to clarify the position going forwards. Other areas under the new law, there's no reduction for resignations. So that's going to change. That will also mean that there's a higher payment of gratuity for people who resign in the first 5 years of service under the new law. No reference to being able to provide pension in lieu of gratuity. That's not very common in the private sector anyway. I don't think that will have a huge impact. And gross misconduct dismissals as well. Under the old law, gross misconduct dismissal, 0 entitlement to gratuity. Under the new law, it's silent, which suggests that if somebody's dismissed for gross misconduct, they are still entitled to end of service gratuity. So those are the key sort of takeaways for gratuity. What I would say, just remember, the new law is implementing some changes around gratuity, and if something comes in and you're not quite sure what the calculation should be, of course, drop us a line or drop Creative Zone a line, and we'd be, we're always happy to help with those sort of things. And then the final key topic, of course, is terminations and compensation arising out of the termination of employment. First thing to mention here is probationary periods, terminations or resignations during probationary period. That has changed under the new law. And it's changed, I think, in favour of companies. And something a lot of clients, private sector, used to say to us is, it's such a shame when we hire expats, and it's a 90% expat workforce, of course. When we hire expats, we pay recruitment costs, they come to the UAE, start with us, we get their visa, and then they resign within a few months to go and join a competitor or join another company in the UAE. And we've lost money because of that. While the new law addresses that under Article 9, it says that if a person resigns during the probationary period to join another UAE-based company, the original employer can require the new employer to compensate them for the recruitment costs. So it's perfectly possible to recover those costs from the new employer. And in addition to that, the employee has to provide 1 month's notice to resign during the probationary period if they wish to join another UAE employer. So a little bit of protection for UAE companies when bringing expat employees into their organizations there. Outside of that, if it's a company dismissal or if the employee resigns because they want to go home to their home country, then it's just 14 days notice of termination in those probationary periods.
But if it's within the UAE and the employee wants to go to another company, has to now serve 1 month notice, even if it's within the probationary period?
Exactly. And the company can get the recruitment costs from the new company as well.
How do we go about establishing what those recruitment costs could be?
Great question, Lorenzo. And this is something that's come up. Is recruitment cost defined in the labour law? No, it isn't. So it's really up to companies to define that. And we would recommend when you're reviewing your employment contracts, you have wording relating to the probationary period that protects you under the new labour law. You say, look, if you resign to join another UAE company, you've got to give us 1 month's notice as per the labour law, and we will be entitled to compensation for our recruitment costs. And by the way, recruitment costs means visa, means health insurance, maybe it means a flight to bring you into the country as well. And I, of course, I would recommend that our clients are as aggressive as possible in that clause, because if you've paid those costs and somebody leaves to join another company, you should be entitled to recover them under the new labour law.
And especially now knowing that they need to serve 1 month notice period, even if it's within that probationary period that they're in. This is interesting, yeah.
Yeah, exactly.
Luke, sorry, a question that's been asked is around, so under the old law, there was the concept of compensation if you had a fixed term contract. So what the position is under the new law around that element of compensation.
Yeah, thanks very much, Michael. And this is a really important change, actually. So thanks for raising that question. Because under the old labour law, if you wanted to terminate a fixed term contract early, you could only do that if it was a gross misconduct dismissal. You could not, for example, terminate a fixed term contract early for poor performance. In that situation, as the question is getting at, you had to pay 3 months compensation to terminate the fixed term contract early. Under the new labour law, that it is possible to terminate a fixed term contract early and with notice. Article 42 of the new labour law talks about different reasons, different circumstances where companies may terminate a fixed term contract early, and there's also sort of a catch-all that talks about terminating with notice for a good reason or for a legitimate cause. So it is possible now to terminate a fixed term contract early with notice for a good reason. The answer to the question, Michael, if that dismissal is deemed to be unlawful because the court say, well, we don't accept the poor performance reason you've given, the maximum compensation is still 3 months pay that an employee can be entitled to receive. And then the other point on this slide here about terminating without notice, Article 44 dismissal, the new Article 120 dismissal, the gross misconduct type reasons for dismissal under the new labour law. As I mentioned earlier, there's been two new grounds actually that have been added to gross misconduct dismissal. So a lot of what was in the old law has been retained. So it's things like terminating for disclosing secrets of the organisation, terminating for coming into the office under the state of intoxication, gross misconduct offence, again, as it was under the old law. But these two new grounds have been added. So abusing a person's position to obtain personal gains, that's what I was talking about earlier, the sort of corruption where people are receiving paybacks or money on the side, or joining another company without getting the consent or approval of the current employer would also be a gross misconduct offence. So that's just for you to know, have a think about your termination policies and procedures, make sure they reflect the new labour law, and obviously this is relevant to the new fixed term contracts as well. So this is a summary of everything we've covered. Employment contracts, please look at them, and please review them and get them ready for the new labour law. Statutory benefits, Michael took us through the key statutory benefits. Just be aware of those. Make sure you're providing those statutory benefits to your employees. Discrimination, a very important topic, and some interesting questions in relation to discrimination. And then the two topics I've just covered, gratuity and termination policies and procedures. So that takes us to the end of the slides, Lorenzo. We've probably got 5 minutes to go through all 20 of those questions that are outstanding.
And another important point I think we didn't cover, and I think is quite important, we received quite a few questions ahead of today's session, which is the issue of the non-compete and the non-competition clause. I understand that now, as per the changes to the law, the employer is able to add a non-compete clause within the employment contract. And so how is the applicability of non-compete clauses as to what it used to be in the past?
Yeah, thanks very much, Lorenzo. So Article 10 of the new law specifically talks about non-compete clauses. And what's really interesting is says that a non-compete clause cannot exceed 2 years. So potentially you could have a restrictive covenant that's up to 2 years. It still has to be reasonable though. So it depends on the seniority of the person and the risk to the business. But it's good that this has been included in the new labour law. There was actually a reference to restrictive covenants in the old labour law, but it's been updated and developed by the new labour law. The question always is, well, are they enforceable? They are recognised by the courts, they're enforceable, but generally to the extent that the court can award compensation to the company for any losses arising out of an employee's breach of the restrictive covenants. That's where the real teeth are around restrictive covenants. What we cannot really do in the UAE, the courts do not have the authority to do this, is to issue an injunction, a court order that says, Lorenzo, you cannot work for a competitor or creator zone, or Luke, you cannot work for another law firm, as a court order. That's a court order to you, Luke, that you can't do that. You can't get that in the UAE. But what you could do, what Pinsent Masons could do, is claim compensation for any losses that they could experience if I was to go and work for a competitor.
Does the issue of gardening leave then needs to be observed if the employer wants to enforce a non-compete?
So gardening leave is a period of leave that a company can put an employee on during the notice period. So if a really senior person resigns as CEO and they are going to be a risk if they're out there in the market during their 3-month notice period or 6-month notice period, the company can put them on gardening leave, which basically is, CEO, we're still going to pay you, you're still going to be employed, but you have to stay at home, you can't contact any clients, you can't contact any employees, you can't do any work, and you just have to stay at home, and we're going to take your laptop and your phone off you. That keeps them out of the marketplace. And then in addition to that, you could have then a restrictive covenant to say, you can't join a competitor once the employment terminates as well, which would be kind of a double impact on the CEO.
Mm-hmm.
And sorry, just to add on to that, I think the point to be careful on that is if you do have for example, quite a long notice period, so a 3-month notice period, and then you have a long non-compete on top of that, the length of the gardening period could impact on how reasonable the non-compete period is. So often what employers say is you'll be subject to a 12-month non-compete. However, any period you spend on gardening leave will be taken out off that non-compete period, and that helps show the employers being reasonable, because the employees effectively out of the market by sitting on garden leave.
I'm going to try to read a few questions that we've been receiving, and for those that still have a few questions, please try your luck and put them on the Q&A section, and we will try our best in the 5 minutes that we have left. There's a good question that says, can the employer decide how many months notice to give after probation has been passed? Is there a maximum number of months notice that an employee has to could be attained to?
Yeah, so I think what the new labour law talks about is a notice period between 1 and 3 months, and so I think that's the sort of parameters that companies should work within. I mean, we do still see companies that will have longer notice periods because they think that's what's required for a senior person. But where it's a very long notice period, for example, 6 months, there is a risk that when if the employee then resigns, they will say, well, hold on a minute, my maximum of obligation under the labour law is 3 months, so that's what I'm going to work. So yeah, that we would recommend it's between 1 and 3 months.
Excellent. Another set of reforms that I've seen were applicable in these changes were the issue of the employer being able to confiscate or keep the passport of the employee. I think there is an important line on these changes to the law that says this is no longer something that employers can do.
Yeah, I think there is something in there on that. I mean, that's actually been the strict legal position before this new labour law, that companies are not permitted to take away an employee's passport, although we know that it does happen in practice sometimes. But yeah, I think that's correct, Lorenzo, that is also the position under this labour law as well, that companies should not be, they're not permitted to withhold passports.
Right. Is the Minister of Human Resources going to be releasing new contracts that are going to be sort of used as a template for employers to submit their contracts to labour law?
Yeah, that's what we've been told. That's what was the position when the labour law came in, and I think that there is something in here that talks about the authorities, not just the ministry, but also the free zones, you know, developing, introducing new employment contracts. We haven't seen a copy of a new employment contract yet, but that definitely has to happen, because the old version of the ministry contract refers to the 1980 law, and it's unlimited or fixed term. So the unlimited term contracts will presumably go away. So yes, there will be updates to those.
Well, we have many people asking for a link to today's session. We'll be forwarding this, and if Luke permits, we might also be sending you the presentation of today. Although I'm sure there's been a lot of people doing screenshots out of today and trying to get as much as we can. Truly, this is very valuable information, Luke, and we really thank you for today. Maybe to wrap this up, Luke and Michael, maybe just your final thoughts for today, and what would you recommend people watching this webinar?
Thank you, Lorenzo. Michael, you first, please.
Sure. Yeah. So I think the key point to take out, and obviously there are lots of changes. I think is the key point is you just need to do an audit of your employment contracts and your employment policies. So whether that's an internal audit or getting them reviewed by an external party, because so much has changed. It is very easy to overlook something. So just take the time to carry out an audit of, you know, what policies, what documents you've got in place, how much they need to be changed to reflect the new labour law, and then making sure that that's communicated throughout the policies, because throughout the organisation, because often a lot of the problems we see amongst clients is where, for example, managers have taken it upon themselves to take decisions, and they're perhaps not up to date with the current requirement, current laws, current policies, and if they aren't aware of the changes, then often where issues can arise. So I think that's my key takeaway, is to carry out an audit and to then make the changes and then communicate those throughout the organisation.
Thank you, Michael. And I agree with all of that. I think that's absolutely the sort of takeaway. And when undertaking that audit, the priorities, I think, right now are the employment contracts and end of service gratuity. Try to get on top of that, get a company position on how you're going to calculate gratuity in this immediate sort of 1 to 2 month period. And as we said, you know, as Michael said, do the audit. In particular, the priority should be your employment contracts.
Excellent. Great. Well, look, Michael, really, we truly thank you for today's session. We're getting a lot of requests saying that I think we need a catch up in about a month from now for doing an updated version of things. I think this is an important topic. Maybe we'll try to catch up again in about a month or so and see where the changes have come in place and how we're going about executing this. But once again, Luke and Michael, thank you so much for today. Yeah?
Thank you very much. As I say to all of my friends, Lorenzo and friends at Creative Zone, let's not leave it so long before the next catch up and definitely when the new executive regulations come into force. Thank you. Excellent. Thank you, guys. Thank you to all the attendees, and we'll see you again in the next one. Thank you all. See you again. Thank you. Bye-bye. Bye. Bye.